My name is Volker Kruger from Velden-Duffey Attorneys, and I'm joined by Janus Olivier from our Commercial Law Department. Thanks for joining us, Janus.
Thank you, Volker. It's a pleasure being here.
Topic is conflict of interest. I think most of our listeners would have heard of this principle and the fact that you should avoid any conflict of interest if you are in a responsible position, for example, as a government official and need to take important decisions in respect of tenders, etc., then you shouldn't be involved in that decision if you could enrich yourself by being part of that decision and allocating, for example, a tender to a certain company where you or your family member has any interest in it. But today we would like to discuss a certain court case which deals with companies and specifically the board of directors of a company and their obligation also to avoid any conflict of interest. But yeah, Janus, interesting case, I believe. Please explain, what are the facts?
Okay, yeah, interesting case indeed. This was a judgment in the commercial court in Johannesburg. So it's not just the High Court, as I think most of the listeners would normally hear your guest refer to. It's a specific commercial court, and it dealt with Section 75 of the Companies Act. So Section 75, in a nutshell, as you mentioned now, it deals with a personal financial interest, and it places an obligation on a director to share that financial interest, the personal interest, with his co-directors on the board. So basically just to ensure impartialness when a decision is taken and to ensure that there remains objectivity in the board during the discussion of a specific instance. So he must disclose his financial interest to the board, and then he must actually leave the meeting. He's not allowed to partake in the consideration or the discussion at all, and he may not sign any documents in respect of that matter unless, of course, if the board specifically asks him to do so. But the idea behind this section is quite clear. You're not allowed to participate in a decision if you have an interest. So in this judgment, it's at the Spark Holdings versus State of South Africa. There was a specific individual, Mr. van Breda. He, of course, had a personal financial interest, and he didn't disclose that to his co-director. Now, for purposes of our discussion today, I'm going to keep the facts as simple as possible, just so that we can explain the principle here. But it was actually quite a lengthy decision and some interesting corporate structures that was used by Mr. van Breda. So Mr. van Breda and Mr. Moonse, they were the directors of a company. I'll just refer to it as Company A. So Company A was running a business, and it was renting an immovable property from Company B. Company B then went on to sell that property to Company C, and the lease agreement was, of course, entered into between Company A and Company C. Obviously, Company A still wanted to use that property. Now, Mr. van Breda, through various entities, he actually owned 25% of Company C, but he never disclosed this to his co-director of Company A, Mr. Moonse. So, in other words, he had a direct personal financial interest. It triggered Section 75, but he didn't disclose this. When Mr. Moonse found out, he didn't want to proceed with the lease agreements anymore between Company A and Company C, and Mr. van Breda then had to go to court to ask the court, can this decision that was taken by the board of Company A not be valid, even though he didn't disclose his personal financial interest? So it isn't. Yes, focus. You have a question.
So the argument is that because he had this personal interest, which he didn't disclose, and he was part of the decision-making process actually as a director, the agreement as such, which was authorized by the directors of the company, is invalid.
Yeah, so Section 75(7) specifically says if an agreement or if a decision is taken contrary to Section 75, in other words, if there was no disclosure of your interest, that decision is automatically invalid unless the shareholders just approve it or rectify it by way of an ordinary resolution. And if they don't do that, you have to go to court, and that decision must be declared valid by court. So in this judgment, the shareholders didn't rectify or ratify the decision, so Mr. van Breda went to court through this Company C, and that is the commercial judgment that we dealt with. So in the court, the question said, or the court rather said, the question isn't only whether Mr. van Breda had a duty to disclose this personal financial interest, which he of course didn't do, But the second aspect that the court looked at is whether or not there was a duty on Mr. van Breda as a director of Company A to disclose this corporate opportunity to Company A that they can actually buy this property and stop renting it. And we know now Mr. van Breda didn't do that. In fact, what he did, he kept silent. He entered into a transaction when Company C buys the property and he owns 25% of Company C, concluded a lease agreement with Company A. He, as the director, personally actually concluded that lease agreement, and of course he would benefit at the end of the day because he has a personal financial interest in Company C. Now, Mr. van Breda's first argument was that he actually didn't have a duty to disclose because he didn't have a direct financial interest. He only had an indirect interest because it wasn't him as a director that personally owned the shares in Company C. It was through various other entities that his family trust actually owned the shares. And you'll see this a lot.
But surely that doesn't matter now. I mean, substance over form, no?
Exactly, and that's what the court also says. And I mean, it makes sense. So his family trust owned the shares of a company which owned the shares of a company, and at the end of the day that company owned shares in Company C. But the court said it's very clear that you have a financial interest in Company C. And I totally agree with the court's argument here that if it was so easy just to bypass Section 75 by not holding the shares directly but just holding it through another company, there would actually never be a duty to disclose. So the legislator foresaw this, or foresaw this rather. And then the second issue was now the duty to actually disclose this corporate opportunity, which Mr. van Breda also didn't do. And here the court said, even though it isn't specifically mentioned in Section 75, that you have, as a director, have a duty to disclose a corporate opportunity to the company if you are on the board, it's still a fiduciary duty of a director. In other words, part of the common law. And the common law wasn't changed when the Act came into operation. Legislation only alters the common law if it specifically says so in the legislation. But in terms of the Companies Act, it didn't change this fiduciary duty of a director to also say there is a corporate opportunity. So, in other words, the court said that what Mr. van Breda should have done is say, basically, hello, my co-directors of Company A, there is an opportunity when we can actually buy the property that we are currently renting, and then we can stop to pay rent, which will save us money at the end of the day. But Mr. van Breda didn't do that. He kept quiet. He bought the property through another company and then concluded the lease agreements to his own benefit. So, it's very easy, in my opinion, to agree with the court in this decision. The application that Mr. van Breda now brought to how that this decision was valid, the court dismissed this application, and the conclusion of the lease agreement between Company A and Company C was then, of course, found to be invalid, or it actually remained invalid because Section 75 automatically rendered it invalid.
I think that second part of what you just explained now is fairly far-reaching. Now, the duty on a director also to disclose a corporate opportunity. So 75 goes that far to place that obligation, and I guess it just goes to show you how important that fiduciary obligation is. Although it's not directly based on Section 75, as you now said, but I mean that's the effect of this judgment, I would say. No? So you need to also proactively disclose any corporate opportunities to do your work as a director. So it's a very severe obligation, that fiduciary obligation that the directors have, is to always act in the interest of the company as the director of that company, and not in his personal interest.
Exactly, Volker. Yeah, the idea behind the company, I would argue, is that the shareholders appoints the director to act in their best interest. The director runs the company, and the director shouldn't now make decisions for his own benefit. He owes a duty to the company, and Mr. van Breda didn't comply with that duty. That's basically it.
All right. So yeah, that then affects the validity of any agreements, as we now saw. In this case, the lease agreement was declared invalid. So if there's any situation that the listener is faced where there is such an agreement and there are doubts as to whether the director should have been involved in a decision, where there's a conflict of interest, keep this decision in mind. You might be able to attack the validity of the agreement based on that. And I think the advice to any director of a company is at all times avoid any conflict of interest. And the definition of a conflict of interest, etc., might sound fairly complicated. And if you read Section 75, maybe it sounds fairly complicated, but the basic principle, I think most laymen would be able to apply. I mean, most people would have a feeling when they need to take any important decision that, look, at this stage, there's some personal interest which is relevant for me to take this decision. And as soon as that happens, as soon as there's any personal gain or benefit that I could have myself, as opposed to the company having the benefit, then I need to not be part of that decision, whether that's board of directors, whether that's a government official, whether that's any fiduciary position that you might hold. Would you sort of agree with that summary?
Yeah, Volker, 100%. I would argue in a nutshell that if something happens that affects your ability to remain impartial, then you have an interest in that matter. Disclose it to the board. Rather come clean, even if you disclose it out of an abundance of care, as we say, you didn't really have a duty to disclose it. Tell the board of directors you won't be able to be impartial in this decision. This is why, because your mother, for example, has an interest in the company, disclose that to the board, excuse yourself from the meeting, or rather let them say, it's fine, you can sit in. We don't feel there's a duty to disclose, or you have complied with Section 75, but always act in the best interest of the company, and then, bona fides, as we say in the law.
All right. Thank you, Janus.
Okay.